All right, today we're going on a journey. We're going to trace the entire roadmap of a civil lawsuit in India. We're going to follow it from the very first disagreement all the way to a final court order to really get a handle on how civil justice actually works.
I mean, have you ever really stopped to think about it? When one person sues another, what really happens? What are the steps? It can feel like this super mysterious, complicated process, but you'll see it's actually a highly structured journey with a very clear map.
And that map, the master rulebook that controls every single move in the game, is called the Code of Civil Procedure, or the CPC for short. Now, this thing was written way back in 1908, and it's the blueprint we're going to be following today.
Okay, so let's start with the basics. What exactly is this code, and what's its job?
You know, the best way to think about the CPC is like an operating system, like Windows or Mac OS, but for the civil courts in India. It doesn't actually decide who's right or wrong. That's what other laws are for. Instead, it just sets out the procedure, the how-to for running a case. It's all about making sure the whole process is orderly, fair, and totally predictable for everyone involved. It levels the playing field.
So, you have a dispute. How do you officially get the wheels of justice turning? Let's take a look at the starting line, kicking off a lawsuit.
Okay, the very first and maybe the most important decision is picking the right court. You can't just file your case anywhere you feel like it. And if you get this wrong, your case could be thrown out before it even begins. So the CPC sets up two main filters. First up, you've got pecuniary jurisdiction. That's all about the money. The financial value of your claim determines which level of court you go to. And second, there's territorial jurisdiction. This one is all about geography, where the property is, where the person you're suing lives, or where the whole thing went down.
And what's really cool is that the code itself gives us these clear, simple examples. Check this one out. The defamatory stuff was published in Calcutta, so the wrong happened there. But the defendant, A, lives in Delhi. The CPC says, hey, B, you can sue in either city. It gives the plaintiff flexibility while making sure the lawsuit still has a logical connection to the place it's filed.
So once you've figured out the right court, you have to formally state your case. And you do this by filing a document called a plaint. Now think of the plaint as the foundation of the entire lawsuit. It's the official story from the plaintiff's point of view. It lays out the facts, the legal arguments, and most importantly, what they want the court to do about it.
So this really breaks down that whole launch sequence. Step 1, figure out the where, that's jurisdiction. Step 2, prepare the what, that's your plaint. And step 3, you file it. And boom, you've officially instituted the suit. That is how a case gets off the ground.
But a lawsuit isn't a monologue, right? It's got to be a dialogue. So now, let's flip the script and see how the other party, the defendant, gets brought into the picture.
For this whole process to be fair, the defendant has to know they're being sued. So the court makes sure of this by issuing what's called a summons. And let's be clear, this isn't just a friendly invitation, it is a formal command from the court to show up and respond. This is a huge deal. It protects the basic right to hear and answer any accusation made against you. The whole case grinds to a halt without. That summons kicks off a formal exchange of documents, which are called pleadings. The plaintiff has already filed their plaint, right? So now the defendant gets to fire back with their formal point-by-point response. And that document is called the written statement. Once both of those are in, the battle lines are officially drawn.
With both sides having laid out their arguments on paper, we move to the main event, the trial. This is where the facts get tested, the evidence gets presented, and the case is truly argued out in the open.
And the trial itself is a very structured journey. It starts with the court framing the issues. This is where the judge basically boils everything down and says, okay, here are the exact questions we need to answer to resolve this. Next is discovery and evidence, where both sides have to show their cards, present their documents and proof. Then you get to the part everyone knows from the movies, the examination of witnesses, where people take the stand. And finally, the lawyers for each side get up and make their final arguments, trying to tie everything together for the judge.
After all the evidence and arguments have been heard, the court has to make a decision. So let's look at the verdict and how that decision gets delivered and made official.
Now, this is a super important difference to understand. The court's decision comes in two parts. First, there's the judgment. This is the why. It's the judge's long, detailed explanation for how they reach their decision. Then you have the decree. This is the what. It's the short, formal, official order of the court. It's the one-liner that says, pay this money or hand over that property. So to put it simply, the judgment explains, the decree commands. But what about all the money spent on lawyers and court fees? Well,
Section 35 of the CPC gives the court the power to award costs. What this usually means is that the losing party is ordered to pay for the winning party's legal expenses. The goal is to make the winner whole again.
But hold on, the story isn't quite over. A decision on a piece of paper is one thing. Making it actually happen in the real world, or fighting it, that's the final chapter.
I mean, think about it. A decree is just a piece of paper until it's enforced. Part 2 of the CPC is all about execution, and that's the process of turning the court's order into a real-world result. It's about making sure the losing party actually does what they were told to do.
And the CPC gives courts some serious power to make sure its orders are followed. We're not just talking about sending a strongly worded letter. As you can see from Section 51, a court can order the physical delivery of property, it can seize and sell the losing party's assets, and yes, in certain situations, it can even order their arrest and detention in civil prison. That just shows you how much weight a final court order really carries.
But what if you think the court just got it plain wrong? Well, the CPC provides a few ways to challenge a decision. The most common one is an appeal, where you take your case to a higher court. Then there's something called a review, where you ask the same court to take another look, usually because of a clear mistake or some new evidence that's popped up. And finally, there's revision, where a higher court just checks to see if the first court made any big legal or procedural errors.
So we've walked this whole intricate path, a path laid out by a law from 1908, all designed for order and fairness. But it leaves us with a pretty big question, doesn't it? In today's world, is this century-old, super detailed roadmap still a guarantee of justice? Or has it maybe become a complicated maze that actually slows the whole journey down? That's definitely something to think about.